Have you ever wondered about the foundation of South African law and how it has evolved over the years? Indeed, the legal history of South Africa is a riveting tale, filled with twists and turns that have shaped the nation's current legal landscape. From its indigenous roots through the tumultuous colonial era, the dark period of apartheid and into the modern era, South African law has undergone significant transformations. Each period of this progression carries its unique contributions, molding a legal system that is as diverse as the nation itself. Understanding this evolution is not only fascinating but also crucial, especially for those immersed in the legal field. It helps us appreciate the principles that guide the present legal system and the historical context that birthed them. So, ready to delve into this captivating story? Let's embark on a journey through time to explore the rich and complex history of South African law. Our journey begins in a time before colonial influence, with indigenous African law. This era, devoid of European influence, was a time when customs and norms ruled, shaping the societal behavior in what is now known as South Africa. The legal system of this period was deeply rooted in the traditions and cultures of the indigenous people. It was a system that was not codified in the way we understand law today. Instead, it was an unwritten law, passed down orally from generation to generation. It was a law that was lived and experienced, deeply interwoven with the daily lives of the people. In this pre-colonial era, law was communal in nature. It was not about punishment, but rather about restoring harmony within the community. In essence, it was a restorative justice system. The community, led by a chief or elder, would gather to hear disputes. The aim was not simply to determine right from wrong, but to heal the rifts that disputes caused within the community. Disputes were resolved in a manner that sought to restore relationships and maintain social harmony. The process involved negotiation, mediation, and where necessary, reparation. It was a system that valued reconciliation over retribution, focusing on healing rather than punishing. Yet it's important to note that this system was not without its flaws. Much like any other system, it had its share of injustices, often hinging on aspects such as gender and social status. However, it was a system that worked for its time and place, shaped by the unique cultures and traditions of the indigenous people. As we move forward in our journey through the history of South African law, it's essential to remember this foundation. The roots of the legal system are deeply embedded in these pre-colonial customs and norms. It's from this bedrock that the layers of Dutch, British, and modern South African law were built. This indigenous law formed the bedrock upon which subsequent legal systems would be built. As we delve deeper into the evolution of South African law, we'll see how these layers interact and shape the legal landscape as we know it today. As we move forward in time, we encounter the significant impact of colonial rule on South African law. When the Dutch East India Company established Cape of Good Hope as a refreshment station in the 17th century, it brought with it the Roman Dutch law. This legal system was a hybrid of Roman civil law and Dutch custom, and it became the law of the Cape. It was marked by its pragmatism and flexibility, and was often applied in ways that were sensitive to local customs and traditions. However, the arrival of the British in the late 18th century introduced a new legal order. English law was superimposed on the existing Roman Dutch law, particularly in commercial and procedural matters. This imposition was not without resistance, leading to a complex fusion of Roman Dutch and English law, and while the colonial rulers came with their laws, they didn't erase the indigenous legal systems. Instead, what transpired was a parallel existence of different legal systems. The indigenous laws were relegated to the sphere of native or customary law, applied only to African inhabitants. This dual legal system was a tool of control and segregation, and it further complicated the legal landscape. The enforcement of these laws also had profound social and political consequences. They dispossessed indigenous people of their land, disrupted their societies, and entrenched racial hierarchies. This was not just a legal imposition but a political project, aimed at ensuring the economic dominance of the colonial powers. But the colonial era also saw resistance and the emergence of anti-colonial legal thought. African leaders used the courts to challenge the colonial authority, and they invoked customary law to assert their rights. This was an important aspect of the wider struggle against colonial rule. The colonial era left an indelible mark on South African law, shaping its evolution in profound ways. The colonial laws and the indigenous responses to them laid the groundwork for the legal developments that were to follow. And while the vestiges of colonial rule have been challenged and reformed, their influence is still apparent in the law we see today. Next, we traverse the tumultuous period of apartheid, a time of oppressive laws and fervent resistance. The apartheid era, stretching from 1948 to 1994, was marked by a system of institutionalized racial segregation and discrimination. The law was the instrument used to enforce this system, with legislation such as the Population Registration Act, the Group Areas Act, and the Bantu Education Act, among others, serving to entrench divisions and inequality. These laws created separate and unequal spheres for different racial groups, restricting where people could live, work, and learn. They were enforced by a powerful state apparatus, with the judiciary and police playing key roles in maintaining the status quo. But the law was not only a tool of oppression, it also became a weapon in the hands of those who sought to resist apartheid. Legal challenges to apartheid legislation, both within South Africa and internationally, put pressure on the regime. Lawyers and legal organizations played a crucial role in this struggle, representing those charged under apartheid laws and challenging the validity of these laws in court. The end of apartheid in 1994 brought significant legal reforms. The cornerstone of these reforms was the new constitution, adopted in 1996. This document, hailed as one of the most progressive in the world, enshrines principles of equality, human dignity, and freedom. It also established a constitutional court, tasked with upholding these principles and ensuring that all laws align with the Constitution. The legal landscape of South Africa was transformed in the aftermath of apartheid. Laws that had enforced racial segregation and discrimination were dismantled. In their place, a new legal framework was erected, one aimed at redressing past injustices and building a society based on equality and justice. The end of apartheid heralded a new era for South African law, one defined by the pursuit of justice and equality. Finally, we arrive in the present, where South African law continues to evolve and adapt. The cornerstone of modern South African law is the Constitution of the Republic of South Africa, adopted in 1996. This profoundly transformative document enshrines the rights and freedoms of all citizens and serves as the supreme law of the land. It has been hailed as one of the most progressive constitutions in the world, reflecting a commitment to social justice and equality. The judiciary, an independent branch of the state, is charged with interpreting the Constitution and the law. It is composed of various courts, with the Constitutional Court at the apex. This court plays a crucial role in upholding constitutional rights and values, and its judgments have profound implications for the lives of South Africans. In recent years, South African law has seen significant developments. The Traditional Courts Bill, for example, aims to recognize and regulate the role of traditional justice systems. While its potential to enhance access to justice in rural areas is widely acknowledged, it has also sparked debates about the balance between customary practices and constitutional rights. Another key development is the focus on social and economic rights. South African courts have handed down landmark judgments in areas such as housing, healthcare, and education, pushing the boundaries of justiciable rights and highlighting the role of law in addressing social inequality. In the sphere of criminal law, efforts are underway to modernize the legal framework and enhance its effectiveness in combating crime. This includes reforms to the bail system, sentencing guidelines, and the management of correctional facilities. As we navigate these developments, we see a legal system that is dynamic, diverse, and deeply rooted in the country's unique history and context. It's a system that faces significant challenges, but also embodies great promise. As we look to the future, we see a legal system that, while shaped by its past, is firmly focused on promoting justice and upholding the rights of all citizens.